for your convenience. And today we have a great topic, key agreements that all small business owners should have. We have Jeremy Bombard from Bombard Law Offices with us today. We anticipate that he's going to be providing you with a lot of great information, and we are recording so that you can watch it again to get anything you missed. But I'd like to first talk about SCORE. We do offer training for small business. We have a lot of great sessions coming up in the new year, a lot of new topics for us. I encourage you to check out the website, watch for our newsletter. Like I said, lots of great training opportunities. The most important thing that SCORE does, however, is the mentoring. Our mentors are volunteers, and they come to us with a lot of different experiences and knowledge that they want to share with you. Who do we work with? We work with the folks that are, gosh, should I be starting a small business? I'm not sure. To the folks that are in the process of putting together that business plan and figuring out what entity they want to be, to the folks that are already in business and maybe they have questions on a specific business topic, or they're trying to grow a certain area of their business, etc. So we work with the whole range. Sessions for that first session, we'll try and make sure you get matched to a mentor that you can work with. The first session is in that 30 to 45 minute range, and they will go over what your goals are, learn a little bit about you and where you are, and formulate a plan. And as you work with that mentor, sometimes other mentors are brought in to fill in any gaps. And sometimes clients can end up with like a team of mentors that are working to assist them to be successful. You can get a mentor in a couple different ways. You can put a note in chat and I will make sure the right chapter reaches out to you, or you can look on the chapter websites, and I will put those in chat after my beginning intro. There's all the chapters in our district. While you're on that website looking for a mentor, I encourage you to check out the library section. There's lots of little tools and templates and little tidbits of information that you absolutely will find completely helpful. So the format for today, because we do anticipate we're a good crowd today, will be Q&A tab. That will be for questions you want asked to the presenter. Everything else can go into chat, not a problem there, but if you could put your questions that you want asked to the presenter in the Q&A tab on the Zoom bar, that would be very helpful. Our goal is to present questions in between each of the sections. We will ask questions that you've posted pertaining to that section. Anything that's a little bit more generic, we will be saving till the very end. And again, we will be recording today, and I'll put that link because some of our recorded webinars we're having a little technical difficulties posting to the website, but I will send you our YouTube page so that you can look for them there. They're definitely there. Okay, that's all I have for now. So I'm going to go ahead and turn it over to Jeremy. It's all yours.
Thank you, Teresa. As Teresa said, my name is Jeremy Bombard. I own my own practice. I've been business law for about 10 years now or so, and specifically over the past 5 I own firm with a focus on the small and more specifically the micro businesses that are usually a solo owner. There's up to 4 or 5. So, thought we just lost me there for a second.
Yeah. And your screen isn't shared anymore. It stopped sharing.
Let's try that again.
You might turn off your video and just do the share screen if there's. Sometimes that might help with if you've got, I don't know.
Teresa, is it back on now?
Um,
Or am I not sharing anything?
it's kind of stuck. Somehow we have you on here twice. Here we go. Okay, now we've got you once.
So you can't see my screen at all?
Not right now. If you could reshare it.
And
Okay, now it's loading. Okay, we see it. You're set.
okay. Well, I will make this. I will not make sure we get through everything on this. Oh, of course I can't.
Ooh.
All right, I apologize. I don't know what the issue is. So
You can email me the presentation and I can share from my
okay,
from my side, and then that way you can just talk to the slides and I can advance them for you. It might be just you just might not have the bandwidth to do both.
is interesting. Okay, I will do that right now. But as I was saying, I represent small business owners, and go. All right, I just sent it over. Apologize for that. Technical difficulties are part of life. But what I try to do is make a small business owner's life much easier. And I interestingly enough, I just had this conversation literally an hour ago with a mediator I use a lot in business disputes. And we were having a discussion is what leads to a lot of the business disputes. We actually started talking to another business attorney, and the unanimous answer was when somebody starts a business with another business owner, they don't have a written agreement of how the business is going to run. Now, the key things that every business agreement should have is honestly, it comes down to the money. Where does the money go when it comes in? Where does it go out? When does it go out? When does it get sent out? Those type of things are always in an agreement for any type of business. So the first type of business, and one of the more popular businesses that I always set up, is an LLC, limited liability company. It's very basic and straightforward, but it's very comprehensive. I do for solo owners, it's probably 99% LLCs. When you have an LLC, even if you're a solo owner, you should have an operating agreement. There is case law that says if you have an LLC, you do a few things. You file it with the state, you get your EIN number, and then you have an operating agreement. And if you don't do those things, then a court may say, well, now you're not acting as an actual entity. So therefore, maybe you shouldn't get that liability protection, because that's at the end of the day, that's what a lot of business owners want. They want that liability protection and they want those tax benefits. So you set up an LLC, you have somebody, or you if you're a solo owner, you can find an operating agreement online someplace. It's fine. I mean, for a solo owner, I mean, it's not as if you're going to have disputes with anybody except yourself. But if you have multiple owners, you should absolutely hire an attorney to help you with that operating agreement. There's a lot of intricacies, especially in the basics, like I said, money. But here's another thing. What happens if one of the members dies? Where does that interest go? Does it go to the heirs? Does it go back to the company? Does that member get something for that? That's all addressed in an operating agreement. It's something as simple as paying me a few dollars. And when I say few, I'm being facetious. To get that operating agreement in place between multiple owners will save you thousands upon thousands of dollars in litigation down the road. I have had at least a handful of cases, legal cases, litigation cases, where there's disputes between members in the LLC. And my first question to my client is, what does the operating agreement say? And out of all the cases where we've had to go to litigation, the answer was always, we never did an operating agreement. We had a verbal agreement and we were going great. Everything was going great until we had a dispute about money, and then it all fell apart. Well, you know, instead of now you didn't pay me to do the operating agreement. Now you're going to pay me. And this was in discussion earlier, you know, anywhere between $30,000 and $40,000 for litigation. And that doesn't include if we have to go to trial. So you get up an operating agreement, and this is the great thing about an LLC. And this is why a majority of my clients will set up LLCs, is because they're so comprehensive and they're so easy once they're in place that that's it. You don't have to do anything. Once you get into corporations, you have to do more documents, but a limited liability operating agreement, you draft it, you sign it, and that's all you have to do. You don't have to do annual meetings. You don't have to track shares. And this will tell you how the whole entire business is run. There's no questions about where the money goes, who does what, who has the position, you know, what happens if a member dies, where does that interest go? You draft it up, and it's not a complicated process. I will sit down with my client, we'll have a quick conversation, we'll get all the basic information. I will draft it out and I'll have it. It's you know, you're not talking tens of thousands of dollars to draft it. It's little money for peace and quiet throughout the life of the LLC. And as I told Teresa, if anybody has a question about this particular topic, we can ask at each topic section. Does anybody have any questions about LLCs right now?
Yeah, we do have a question. Are operating agreements ever referenced if the small business is audited by the IRS?
So it's never come up. I've never had to deal with that, but I can tell you, if you ever want to get a loan, especially with the SBA, you will absolutely need an operating agreement. But as far as being an IRS audit, I would not put it past the IRS. But in certain circumstances, I've had clients come to me and say, I just did this SBA loan. Now they're asking for an operating agreement. How do I get that done? And then we have to do it sort of in retroactively, you know, date it. So it's, you know, arguably that it was done when the LLC was filed with the state.
That's all we have right now.
Okay. So Teresa, if you can go to the next slide, we get to corporations. Now this corporations, like I said, majority I do LLCs because, you know, a small business, depending on what kind of business, an LLC is much simpler to do. Not that corporations are overly complex, but there's a few more moving pieces. Now, the other thing that business owners should keep in mind is that when you file it with the state, there's annual filing fees. LLC is $520 and a corporation is $265 every year. I've asked the state what the difference is because the annual report process is entirely the same. But the inclination I have is that because LLCs are so popular, they charge more money for it. But it's like I said, corporations, if you do file as a corporation, there's a few more documents you have to but you have to create. First is the bylaws, and bylaws are essentially how the corporation is going to be run, essentially when the meetings are, who's going to be, how many board of directors, who's going to be the officers, how are shares handled. And that's a key agreement that, first of all, every corporation needs, because again, there's information in there about who signs a share certificate. Some bylaws I've seen only the secretary has to sign it. Some it's the president or vice president and the secretary. Some bylaws state that you cannot transfer any shares unless there's a majority vote by the other shareholders. Again, this is usually in a smaller, closely held corporation, but still, bylaws are key because it dictates how how the corporation is going to be run. Again, it's not an overly expansive document, but it's integral to every corporation. And it goes back to what I discussed about the LLC and an operating agreement. If you get sued and through discovery, they ask for your bylaws, you don't have any bylaws, a court could say, well, if you don't have any bylaws, you guess you didn't really treat it as a corporation. We're going to pierce that corporate veil and you could be personally liable. Will that ever happen? Most likely not. But again, why not spend the time and money now, get those bylaws in place? You'll never have to worry about it again. With bylaws in corporations, you have shares. That's how the ownership interest in a corporation is delineated. So you got to make sure you have share certificates. It is amazing when I talk to somebody in a corporation and they're going to transfer their shares to their partner or to somebody else, or they're buying their shares. My question is always, okay, well, can you forward me everything, including the bylaws and any share certificates? And I usually get bylaws every now and then, 50-50. But a lot of time, no one ever does the shares. No one ever drafts up the shares. And I have to tell them that that's what shows you own an interest in the corporation. If you don't have a share, then you don't own anything. Ironically, I just had another case recently where the wife was arguing that her husband sold the company. He never paid her anything for her ownership interest. But through discovery, we found that she had no proof she owned anything. She said, again, it was a verbal agreement. Her husband said she would get 25% of the company or whatever percentage it was. But at the end of the day, there was nothing showing she owned any interest in the corporation. Therefore, the case was dismissed. So arguably the most important thing you need to draft up when you create a corporation are those shares. And I always tell my clients, when you draft up the shares, put together a share certificate ledger. This is a simple Excel spreadsheet that I draft up. And the key part of it is if it's just you, if you're going to be the solo owner of the corporation, again, still draft it up. It's going to take you 5 minutes, or it'll take me 5 minutes. It'll list you, your address, and the amount of shares you own. Your company has 1,000 shares. You own 1,000 shares. It's very simple. But the tricky part comes in is when you start having multiple owners, and those multiple owners will transfer those shares. Or let's say you're a startup corporation and you're transferring some of those shares as ownership interest to get some venture capitalist money. Well, you got to make sure that you track all that, because if you don't, if people start transferring shares, if you just start issuing shares to other entities, then it dilutes the ownership interests. At the end of the day, your share is your vote. If somebody owes 90% of the shares, they get 90% of the vote. Especially if there's a 50-50 split, then you got to make sure that those shares are accounted for, because you don't want arguments of, well, I own the majority share or I own the majority share. You can have that share certificate ledger showing that. And again, you could always look at the share certificates, but again, there's always that issue of sometimes when you transfer those shares, you forget to sign the share certificate, you forget to create the share certificate, and you forget to transfer those share certificates. And what I do is every time there's a transfer, to make things nice and clean, unless it happens once a month or a couple times a month, usually with my clients, it's a few times a year, we'll reissue all the shares to make it nice and clean. I always want to make sure that if there's 100 shares, all those 100 shares are accounted for. There's no question. And then when it comes time to sell the company or transfer those, they're right there in front of everybody. So those are the bylaws, the shares, and the share certificate ledger. Those are the basics that you need for every corporation. Now, if you're going to go into business in a corporation with somebody else, a shareholder agreement is imperative to have. It's very similar to an operating agreement, because what a shareholder agreement does, the bylaws tell you how the corporation is run, but the shareholder agreement gets into the responsibilities of the shareholders, and even more specifically, the money. Again, arguments always revolve around money. When a company makes money, corporation makes money, usually there's distributions that are paid out based on the profit, and those distributions are paid out based on the ownership interest. Now, the question is always, when do those distributions get made? And the great part about it, if everybody's in agreement, you can choose when those payments are made. Same thing with an operating agreement. You can do it once a year, once a month, once a quarter. You can do it whenever there's X amount in profit, but you got to make sure it's in writing, because otherwise one person's going to want money right away and the other person may say, well, let's hold on to it. Let's use that money to build a business. So that's what the shareholder agreement does. It shows who owns what percentage. It tells you when the money is going to get distributed. And it also, the other key part is, especially in a corporation, in an LLC for that matter, it sets out what people's roles are, because sometimes there's you could call them a passive investor, where somebody just puts in the money and doesn't do any work in the company, whereas other people will do work and in return they get a salary. Again, it comes down to money. People start doing work and they say, well, I'm doing all this work. Where's my salary? Why am I not getting paid? Again, what does the shareholder agreement say? Is there any writing that says anybody gets any salary? And if not, then that's where the arguments start to happen. So as you can see from before, the LLC, you do the operating agreement, and the great thing about the operating agreement is you could do anything. I mean, you could, any kind of like random information that you want to put in there, you put in there. Same thing with the shareholder agreement. I've had, I don't want to say crazy requests, but requests that I don't normally see, but it helps explain to everybody that's involved with the company how they, how it's going to get run, what the role is. Are there certain time frames? Are they going to, did everyone put in $10,000? And their goal is, if there's profit at the end, everyone's going to get back 5,000, and then the next year it's 5,000. Those questions need to be answered, and the best way and the most efficient way is to draft a shareholder agreement. I'm looking at some of the questions, and I just saw one about the annual reporting and operating agreement. So all these documents, both for the LLC and the corporation, they are not filed with the state at all. When you first start, you will file either articles of incorporation or organization, or a certificate of organization. That's filed with the state, and that's the basic information. That's the address, president, member, manager. That's the basic, registered agent. Those are the basics. But these corporate governing documents, they aren't filed with the state. In fact, what I do is I always make sure I do e-signatures now with my clients. So therefore, it's on my case management system. I have a copy, they have a copy, and if they ever need a copy of it, it's easily found. That doesn't go out to the public. The only way you would need to show it to somebody, again, is if someone's interested in investing in the company, or if you were going to do a loan and they need to see that to make sure that you're an actual operating entity. The annual reporting is completely different. I do them all online, and it's a simple, if nothing's changed, all it is a confirmation that everything is the same. You file it, and then you don't have to change it. I always tell my clients, if something's going to change, because a lot of times they'll move the business, that's when you want to file that with the annual report, update the address. Maybe somebody's left the company and you haven't looked at it in a year or so. That's when we update that, make sure everything is current. But as far as these governing documents, those are for your personal records only and nobody else's. I'm just looking to see if there's any specific corporation questions regarding, S corp, LL, tax classifications. The best person to answer that is an accountant. I can give you the basics, but an accountant will give you those documents. And then what kind of entity? Again, that's more of a detailed question of what's the end goal? How what's the tax advantages? Again, when you start a business, the best way to do it is to talk to me, talk to accountant, because those are the two reasons people open up LLCs and corporations, is for the limited liability protection and for the tax benefits. Does anybody have any specific questions on these 4 type of agreements that a corporation needs?
Yeah, I think you've hit on what's been posted, so.
All right, then I think we could move on to the next slide. Oh, my screen's acting a little weird, but that should do it. So the other question I get asked all the time is, what kind of, I have an employee, what kind of agreements should I have? It's the first question is, what kind of employee are they going to be? And in fact, so actually the first one is offer letters. I don't think it's the end all be all, but I think, again, an offer letter is 2 pages. It sets out some basic information, and they're very straightforward. And they always, my offer letters have a paragraph in there that if the employee doesn't provide certain information, then they can't work, unfortunately. And that's that can create problems for an employer if they go to hire somebody and they don't submit their tax information or whatever's required to get them on the payroll. That backs everything up. So a simple offer letter. It also sets forth of what kind of employee they're going to be. Are they going to be an employee, or are they going to be an independent contractor? And then some basic information of what the hours are, where they're going to report to. Again, it makes things clear. And down the road, if they ever have an issue and someone says, oh, well, I wasn't told that, or I didn't know that, you have this offer letter that gives you the basic information to your employees, so they can't turn around and say, I didn't know that. How was I supposed to know that? Again, very simple to do. Is it going to make or break your company? No, but for spending a little time with me, getting the offer letter organized, getting out the basic information, getting it to your employee or independent contractor will save you trouble down the road. That actually leads me into my next pitfall that a lot of employers can get into, business owners can get into, is when you hire somebody, are they going to be an employee or an independent contractor? Either way, you need an agreement with them to set forth their responsibilities and what you expect out of them. A lot of my clients, business owners, want to do an independent contractor because A, it's much simpler. You don't have to worry about taxes. You just set them up, you pay them, and that's it. Benefits is always a big deal with business owners. It's a big expense. It's difficult. The problem is Massachusetts, for the most part, unless there's certain requirements, will always classify somebody working for you as an employee over an independent contractor. And so most business owners say, well, yeah, what's the big deal? The big deal is if you do make that error and you don't pay them correctly, and you do have to go to court and argue that fact, it can lead to a lot of fines and penalties. So first off, you should always, talk to an attorney if you're going to hire somebody, or your payroll department. If you have a good, robust payroll company, not so much the bigger names. I find that they're not, especially because they're not local. But if you find a good local payroll company, they can assist you in determining whether that person should be an employee or an independent contractor. Either way, you should still have an agreement with them. The first thing I always have my clients have their employees or independent contractor sign is a non-solicitation, non-disclosure agreement. Meaning, first of all, non-disclosure, if they have access to any proprietary information or confidential information, they're not going to disclose it. You want to make sure that they are aware, the employee or the independent contractor is aware that there is information out there that they cannot disclose. They shouldn't be allowed to give that information to anybody. And more importantly, they're not allowed to take it with them. They cannot take that information with them when they leave or they are fired. That is the company's information. They cannot use it to their benefit whatsoever. In addition, so I usually do a combine where it's non-solicitation, non-disclosure. And what non-solicitation means is that if the employee were to leave either on their own accord or if they're fired, they cannot turn around and try to solicit your current clients for work. Usually there's a time limit. Courts, I put a year. Courts have said, courts are actually now leading more towards a 6-month period, but I still put in a year just as some courts will uphold a 1-year non-solicitation. But that is key because the last thing you want your employee to do is to quit, turn around and reach out to all your clients and say, look, I'm going to do the same thing that this corporation just did, but I'm going to do it for half the price. They are not allowed to do that. That non-solicitation will prevent them from doing that. There's also a provision I put in there that they can't solicit your employees. The last thing you want, and especially nowadays, if you own a business and you have good employees, you need to keep those employees because they're tougher and tougher to find. You don't want somebody to leave and then turn around to your employees and say, look, I'm starting the same business. He's paying you $15 an hour. I'll pay you $20 an hour. Don't want that. You put that in the non-solicitation, therefore that prevents it. Now, the question I always get is, what about a non-compete? Can I have my client sign, or can I have my employees sign a non-compete? The short answer is, for the most part, no. Courts are, Massachusetts courts especially, very strict. If you do a non-compete nowadays, you actually, it can be, the distance is very limited. I don't even know what the recent miles radius is nowadays. 6 months is the tops. But what you also have to do is put a garden leave provision in there, which essentially says if you want to, if that employee leaves and you want to enforce that non-compete section, you essentially have to pay them half their salary while that non-compete is in order. When I explain that to my clients say, well, that's ridiculous. I'm not going to, why would I fire my employee? Why should I have to pay them? But unfortunately, that's the law. The other thing is if you make the mistake of making the non-compete too broad, Massachusetts courts will throw it out entirely. Now, what I tell my clients is if it's a basic generic role that the employee is being hired for, a non-disclosure, non-solicitation should protect you enough. And, even if we try to have a non-compete, the court's not going to enforce it. The courts, if you own a construction company and you hire a laborer, you can't have them sign a non-compete. The courts are going to say that's too generic of a position. You're essentially cutting off their ability to work. Therefore, we're not going to enforce it. Now, if you hire somebody that has a specific skill that very few people have, and you're starting your business solely based on that person's skill, then yes, courts will say, okay, we understand. If that person was to leave, it would basically bankrupt your business. We will do we will allow a non-compete. Again, the best way to figure this all out is talk to an attorney and figure out what the person's role is going to be. Do you need a non-compete, or is a non-solicitation, non-disclosure going to be good enough? That will help. That will protect your business. Because again, at the end of the day, the last thing you want to do is have somebody leave and steal half your business. The second thing I always have a client sign with their employees or independent contractors, either an employee agreement or an independent contractor agreement. Now, what we'll do a lot of times is we'll combine those with the non-solicitation, non-disclosure. But in those agreements, again, it's going to be how much they're going to get paid, when are they going to get paid, will there be any bonuses, and what their roles are. Because again, you want to make sure that, especially in Massachusetts, which is a very heavy employee-friendly state, if for whatever reason you allegedly do something wrong and that employee turns around and sues you, the last thing you want to do is have any ambiguity. You want to make sure that you could say to the court or any government agency that's looking into it, nope, this is how much that person was supposed to get paid, that this is where their roles, here were the hours, here's everything in writing. They're wrong, because you don't want it to be a he said, she said, because I can tell you, Massachusetts will always, not always, but majority of the time side with the employee. And especially in employee-employer cases, if you are found liable, the courts in the law imposes a lot of time, triple or double or triple damages, and then attorney's fees. So if you do $1,000 mistake, that $1,000 mistake can end up costing you, excuse me, can end up costing you tens of thousands of dollars. Excuse me. Now, so all those agreements set forth everybody's responsibility and what you expect out of the employee, what you expect the employee to put back into the company, therefore losing any ambiguity, making sure that down the road, the employee can't come back to you and say, well, you promised me this. You can say, well, I may have promised you this, but if you look at the agreements, this was our agreement. You signed it, I signed it. Here we go. That protects you down the road. Because again, these agreements are just important as your governing documents, because you don't want any confusion down the road that can lead to liability. The last thing you want to do is fight a lawsuit and then end up having to pay a judgment. Now, finally, the other part I have with employees is the handbook. Now, again, if you're going to have one or two employees, again, I always caution my clients, it's always better to err on the side of caution. Even if you're going to have one employee, have a handbook. But if you're going to have multiple employees, a handbook is key, because what a handbook does is it sets forth all your rules and regulations and policies for your company. It'll take things from the offer letter, such as, time requirements, time off, vacation time, sick time, non-solicitation, non-disclosure. A lot of times, actually not a lot of times, all the times it has a drug policy. Setting forth what the company expects from the employee. And what I have my clients do is I will draft this up, and at the back of it, the employee has to sign it saying that they've received it, quote unquote, they've read it, but at the very least they've received it. And you keep that signed piece of paper. So the employee has that handbook, they can look through it all. It can be as comprehensive as you want, but there's the basics that you put in, make sure that there's no question of what the policies of the company are. One of the biggest things that I caution my clients about putting in a handbook is disciplinary. If your employee does something wrong, how are you going to handle that? And more importantly, if they see somebody else doing something wrong that could lead to a lawsuit against you, how are they going to report it? You want to make sure that's clear. And there's a clear step of if someone's going to be disciplined, what are you going to do? Are you going to give a warning, or is it, you do something wrong the first time? Are you fired? Again, you put that in there. Everything's going to be documented. Are you going to have meetings? There should be an employee file for every employee. And additionally, what if an employee witnesses somebody else doing something wrong? How are they going to handle it? Who do they report it to? Now, most of you are saying, well, Massachusetts, an employee is an at-will employee. I can fire them at any time. They can quit at any time. And you're absolutely right. The problem is, just because you fire somebody, doesn't mean they can't sue you. And you want to make sure that if you fire an employee and you get a demand letter from somebody saying, you improperly fired my employee because of X, Y, and Z, you can turn around and say, actually, I didn't. Here's their employee agreement. Here's their offer letter. Here's their handbook. Here's everything they did wrong. I followed the procedures accordingly. See X, Y, and Z. So you have no case. Therefore, again, this even if you provide them all the evidence, they could still sue you. But at the end of the day, if you were to get sued, you could have a counterclaim for wrongful prosecution. And at the end of the day, you just want to make sure that all your bases are covered. You're not going to get any judgments against you, and you're not going to open yourself to any liability. And having these agreements with any employee is going to save you all that time and aggravation down the road. Years ago, I did work for a firm doing a lot of employment litigation, representing employers, large-scale companies, and the employees can sue for just about anything. And my recommendation is cover your bases, get these documents in order, get them signed, get them acknowledged by the employee. It'll save you a lot of time and effort, and more importantly, it'll save you a lot of money down the road. I can't, my screen is not working. Teresa, do we have any specific questions on the employee agreements?
We do have two great questions. This person has unpaid volunteers and interns. They're gaining skills by working for them, doing like websites or maybe some logo designs, that kind of thing. Are there any agreements they should have for these types of arrangements?
Even if they're unpaid, they're still working. I would still have them sign, at least a non-disclosure. Non-solicitation, I mean, it wouldn't hurt because, even if they're unpaid, they may be finishing up school or wherever they're finishing up and may start their own business. But at least a non-disclosure, because you want to make sure that you work hard to have your policies and procedures. Your business is successful because you have these things documented. You don't want anybody taking them or either using them for themselves or giving them to somebody else, giving your competitors an advantage. So a simple non-disclosure, keeping your information confidential and private, is always a good idea.
Okay. We work with a freelance contractor in Kenya, India, and the Philippines based on need. Mostly there are no issues, but are there any agreements we can have to take legal protections in case company is sued by them, and also financial protections in case work is not performed by them? Basically, what kind of agreements will work for international freelancers?
So I've had this case a few times with my clients where they've used international freelancers, and these agreements are all good to use: independent contractor, employee, non-solicitation, non-disclosure. The problem is, and this is what happened with my clients, is that if that contractor breaches that, your options to remedy that are limited. You could sue them here in the United States, but guess what? They're not going to answer. They're not going to come here to defend it. So then you get a judgment against them in the United States, against them in Kenya, let's say. Well, now you have to hire an attorney in Kenya to basically enforce that judgment, track them down, and hopefully collect. Vice versa, if you would actually sue them in Kenya, you would have to hire an attorney, enforce those agreements in an international court. And I'll be honest, I know nothing about Kenyan courts. I don't know if they if they look at U.S. laws and say, nope, those don't apply. Or don't forget, usually if it's an international issue, they're always going to favor the local, the national, as opposed to the international company trying to come in. So having those agreements, again, don't hurt, but just be forewarned. If there's a breach in another country, the ability to collect and enforce is going to be very limited. So what I tell my clients is, not to be negative or pessimistic, but think of that option that could always happen, that if you work with somebody internationally and they breach, you're not going to get anything out of it. So, try to limit, if they owe you X amount of dollars to do work or something, keep that limited, essentially keep everything on a small time frame, so that if they were to breach or do something improper or do something wrong, the window that they have is small, and the ability to damage your company is going to be limited.
And the opposite of that, what can you do to protect yourself from them suing you?
Again, contracts. If you have these contracts and they set out the agreements between you and that contractor, meaning, especially what their role is. Because I have a lot of clients who just say, yeah, I hired this person to do some consulting. And my response is, well, what kind of consulting? That's very vague. You want to be a little bit more specific. And what I always do is I let my client, depending on what they're going to be hired for or what they're going to be hiring somebody for, I usually have them draft up a job description themselves, because they'll have the best idea, and then we can not fine tune that job description. Therefore, there's no, you don't want somebody coming back to you and saying, oh, they hired me to consult and draft this database. And if your agreement says consulting, then a court may say, well, yeah, maybe consulting could be construed to be building databases. But if you have a job description that sets it out succinctly enough, and both parties agree to it, then the court's not going to have any questions. Same thing with money. You don't want to, a lot of clients say, well, I'm going to give them, a percentage of the sales and this and that. And I say, that's fine. But, that could always lead to questions, because, there's always a question of final sales. Is it based on this metric or that metric? Whereas used to a set fee, it makes things clear down the road. Again, if the parties are okay with it, I always caution that the less specificity can always lead to more litigation.
Okay. My business is a recruitment agency and does not have employees, but we do screen and interview the candidates, and our clients decide whether or not to hire that candidate. Should we have an agreement with that candidate, even though they're not employed by our company?
Absolutely. I actually do have a company like that. Majority of the contracts are with the employers that are hiring the candidate you find for them. But at the same time, you especially want to have an agreement with them, because the last thing you want is you're a staffing agency, you find a great candidate, you go to that business, you provide that candidate, the business loves the candidate, they hire the candidate, and then 6 months down the road, something goes wrong. Through no fault, because your job as a staffing agency is to find that person, present it to the company, and it's the company's decision. But let's say 6 months down the road, there's an issue between the candidate and the employer. The candidate is upset, turns around, sues the employer, and sues you. It says, well, you sent me to this company. You knew that they steal money from your employees or something. Well, you want to have an agreement that basically says, our job is to present you to a company. We will do, the basic due diligence, but at the same time, it's your responsibility to choose what company you go with. And more importantly, you want to have some sort of indemnification language, so that if the candidate is upset at the company, they can't turn around and sue you as a staffing agency. You have that indemnification language that'll protect you. And vice versa. If the company, you send them over the candidate, you provide all the information. Well, this would also be in the agreements, but you don't want the company turn around and suing you because, for the candidate lied on their resume. Your job is to take the resume, the information as is, provide it to the company. If the candidate lied, it's not your fault. How would you know that? But again, indemnification language in that situation would protect you for both the candidate and the company you place them with.
Can you hire, if you're a US-based business, can you hire or employ people from another country?
The short answer is absolutely. The more involved answer is you would need to make sure that they are allowed to work in the US. And if not, you need to essentially talk to an immigration attorney and figure out exactly what visas or permits that person needs to work in the US. That's a complicated area. When I have those questions presented to me, that's the first thing I do is I say, talk to an immigration attorney, make sure you're doing everything right. Because if you don't and you do it incorrectly, that will lead to, again, not so much litigation as you'll get investigated by the state, and you'll get fines levied against you.
Okay. All right. Well, I'm going to say we'll go ahead and go to the next topic to make sure we cover everything. Let me get to the next screen here. Other agreements.
Other agreements. So this is sort of the catch-all, and this is a short list. We only had an hour. There are many more agreements. The first big one is, and this always sort of confuses me, if you're going to sell all or part of your company, there should be an agreement showing what you're selling, how much, because you don't want to show up the day of the closing and say, here's my 100 shares of my company. Where's my, $1 million? And they said, no, I thought we agreed it was going to be $500,000. No, put it in writing, figure out what you're transferring and conversely, what you're buying. Especially, a lot of times there's more asset sales than stock sales because of the liability issues. If you buy a company, it's going to be all in stock. Guess what? You take on that liability. Except if you do the agreement between the parties, you will limit that liability. And that's especially if you're selling a corporation and you're transferring all of your stock, you want to have clear language about what liability you'll take on and what liability you won't. You don't want to sell a corporation, and a year down the road, something happens and all of a sudden you're dragged into a lawsuit. Somebody's going to say, well, there's no liability language. You are the owner of the company. I'm saying this is your fault. That can lead to a bunch of problems. So especially in stock sales, you've got to make sure, because stock sales are pretty simple. It's you sign over the stock, they own the company, but you want to make sure that the liability is discussed, especially if you're buying. You want to make sure that what you're buying is what you're bargaining for. You want to make sure that there's no liens on those stocks, there's no lawsuits. The first thing I always do when a client says I'm buying or selling a corporation is I go right to the Mass website, look up the corporation, find out if it's in good standing. A lot of times it's not. You want to make sure the company's in good standing. An asset sale is more where it's just the assets. It's the book of business. It's the equipment. A lot of times it's with landscaping, construction businesses because it's all that equipment. You want to make sure that there's no liens on that. The last thing you want to do is get a bunch of trucks or equipment, go to register it and realize, the prior owner owns $10,000 in fees on it. Well, you're not going to get that money from the seller. He's gone. He took your money and he ran. So you want to make sure those are all in writing. So if there is an issue down the road, because there can be, especially nowadays especially if you're buying the goodwill, you want the seller to stay on for a little bit. Well, that's great. You want the seller to stay on because you want them to transition those clients over to you. But at the same time, the seller's saying, well, I'm not doing this for free or out of the good nature of my heart. Usually they'll throw in a couple of weeks, but at the same time after that, they may need compensation. You want to make sure that that's all in the writing, because I've had that issue where I've represented the seller, I should say that I represented the seller, but a seller has come to me and said, look, I sold my business. They're supposed to pay me. And I said, well, what's in the agreement? And the agreement is very vague. It says, they'll stay on for a month. And I said, well, there's no discussion of compensation here. They said, yes, but verbal agreement that I was going to get paid this much. And I said, well, you're never going to collect it because by the time we sue, you've already going to spent all that money. So anytime you transfer even if it's a part of it, there should be some agreement, especially in an LLC. You'll transfer, a member will leave and another member will come on. But if you're leaving that LLC, you want to make sure that there's no liability that's going to attach to you down the road. You don't want somebody to turn around a year from now and say, well, you were part of the LLC at the time, we're getting sued, so we're going to drag you in there. Get those agreements in writing, set down the details, make sure it's clear. A lot of times, moving on to the next one, joint venture. A lot of time I'll get that with my clients who they're going to go into business with somebody, but it's going to be short term. Somebody does something and the other person does something else, and they mix well together. Actually, the perfect example is real estate. Somebody has the property, somebody else has the money. They're going to rehab the property, and sometimes even a third party where they know a contractor. There's a money person, there's a property person, there's a contractor. They're going to work together, rehab it, sell it, make a profit, and split that money. Well, I mean, think about it this way. It's essentially still a business. There's money coming in, money going out. People have different responsibilities. You could set up an LLC for that, but, do you want to go through that whole process if it's just going to be, let's say, a year? But you still want to put it in writing. You want to make sure that whoever's putting their money up, when are they going to get paid? Are they going to get paid when they sell it, or is he going to get monthly payments? Are they going to rent it out during the time? The person with the property, I mean, that person may be doing nothing except putting up the property, but at the same time, who pays the mortgage during the rehab process? And the contractor, I mean, what's his role specifically? Does he just do the rehab, or is he taking care of everything? Is he gonna get all the permits and deal with that and rent it while it's being renovated? Is he gonna market it, sell it? Again, these things should be put in writing, because again, you don't want to get to the end game, have a dispute, and now you're losing money because you, more often than not, maybe you took out maybe that money guy is collecting 10% interest. He's in no rush to sell it because he's getting 10% interest every month. But the property guy and the contractor want to get this thing sold because they don't want to keep paying him 10%. Again, make sure it's all in writing. It's usually short term. And some clients will come to me and say, look, we have this joint venture agreement. Is it okay? And I say, well, okay, but once you get to the end game, the end goal, let's say you sell that property, is this going to be dissolved, or are you going to do another project? You always want to make clear that once you go from start to finish, but what happens at the finish? Is it automatically terminated? Do the parties agree to terminate it? Is it we're going to keep it in limbo and then do another one? Those are questions that you want to address in the joint venture to make sure that, again, there's not somebody hanging around 6 months after you sell the property saying, all right, what's the next property? If the parties didn't work well together, you want to make sure that you're able to get out of that, have either termination or even one party says, nope, this is terminated, it's terminated. And the last one is basic service agreements, vendor agreements. And what I mean by that is, if you're going to do work, if you have a business, a bookkeeping, consulting, contracting, if you're going to do work for somebody, you should always have an agreement. And my agreements are tailored to the amount of work you're going to do. I mean, I don't do 30-page documents if you're going to, build them a set of stairs, because that's too much work, and you want to make sure both parties are happy with the agreement, but you want that agreement. You want to, again, money, who's paying what, when is the money due? How much do you have to pay now? How much is the whole thing going to cost? If you quote a flat fee and let's say things change, how do you bring that? How do you address that? If you quoted $1,000, but something increased to 5,000, you're not going to do it for 1,000 and lose 4,000. You want to make sure that's in there. How long is this going to last? What's the period of this contract? Is it going to be ongoing? Can a party just terminate it at any time? Or is it going to be one and done deal? You're going to do the work, the agreement is terminated. And we could go into 1,000 different qualifications you put in these agreements, but they're all industry specific. There's always different things that come up in different companies. I work with my clients, and one of the things I always ask is what worries you? Like, what if you start working with this client, what are you worried about? What do you think that could happen that's going to cause you difficulties down the road. Let's address those now in the contract. Let's make sure that anything that could happen is addressed in the contract, so therefore there's no questions. And finally, one of the big things I've been doing lately in the past 2 years is I put a mediation clause in the agreements. No one wants to go to court. No one wants to do litigation. The only people that like litigation are litigators, because that's where they make their money. If you have a disagreement with your client, you want to address that and get it resolved as quick as possible. And I've had a lot of good success lately with mediation. And if you have a mediation clause where it forces the party to go to mediation, you're talking, you're just spending 10% in mediation of what you would at litigation. And I've been fairly lucky this past year, and all my cases in mediation have been resolved. So instead of me spending thousands and thousands in litigation, we go to a one-day mediation. Each party sets out their issues. The mediator renders a decision. It's non-binding. So, I mean, if the party's not happy with it, we can walk away. But usually we're talking about $20,000, $30,000. I mean, you'd spend that in litigation. So if we can come to a somewhat happy agreement, mediation will help get it resolved. You can move on to your next client. Again, we're almost out of time. So, Teresa, any questions specifically on these?
Yeah, I have a couple of questions of things that you haven't quite touched on that maybe we could just address real quick, since they're a little bit different. How important is it to have a privacy policy on your website, which is information driven and not sales driven?
That's a great point. My standard answer: if you have a website, you should have terms and conditions and a privacy policy on it. I haven't seen it come up if you don't have it, if it comes to be an issue. But again, you don't want someone coming to you and saying you're collecting my information improperly. And especially nowadays, that's a huge red flag. But you want to make sure that you have that privacy policy. You want to have those terms and conditions. It sets out how you run your website. If you want to kick people off, what happened, especially, if people buy and sell stuff on a website, those are great. And privacy policy, again, it's good to have, because at some point there's some information collected. You want to make sure that you're upfront about it, and it makes you work with your website designer to make sure that you're specific on what information you are actually collecting. And if you're not going to collect any information, you want to make sure that that's clear and set up properly on the website.
Okay. Well, unfortunately, we're going to have to wrap it up because we've hit our end point here, but definitely encourage you to reach out to SCORE. Jeremy also provided his contact information. And, if there's anything that you're still not sure about, reach out. And thank you all for joining us today. And thank you to Jeremy for providing a lot of great information. And that's all I have. All right.
Thank you, Teresa. I appreciate it. You've been great.
Thank you.